Sanibonani babukelele, a very warm welcome. Sasifikile thina nohlelo Yilungelo Lakho. It's your right. Live khona la kumamba phambili SABC 1 eMzansi for sure mbukeli. Sithembe phela ukuthi nibe namaholiday amnandi futhi aphephile. Siphinde futhi sinifisele konke okusha kulonyaka ka2020. Uyazi ke mbukeli sifikile emhlophe intokazi yakwaJani. Ngisho mina uAlisha ungangibiza uNhlanhla Muthanda. Ngibuya phansi eThekwini emanzi imtoti ngithi sanibonani eBhekulande. Mbukeli uyazi emva kwesikhathi ke ngizovula phela ingcingo ukuthi nisithinte live in studio 0117146918 alternatively 7146919 consumer@sabc.co.za is our email address ikhona futhi ku Facebook as well as kulama SMS. Okwamanje mbukeli asinenishiqe udabeni lethu lokuqala lu live ku2020. Mbukeli miningi manje phela iminyaka abathengi bebulawa izikweletu zokulanda kwezikweletu zabo yilabo phela abaqoqa izikweletu phecelezi ama debt collectors bengenayo nendlela phela yokukhokhela lezo izikweletu zabo zokuqala. Kodwa ke mbukeli ngathi kuzolunga manje njengoba phela sizwa kuthiwa nje abantu bangakhona ukuthi babuyiselwe izimali zabo ezicishe zifike kwizigidi nezigidi zamarandi emva kokuthi phela iCape High Court yenze isinqumo sikaJuqu. And now to unpack what this ruling means, Mbukeli, let's extend a very warm welcome to those who took up this battle for millions of South African consumers. Asamukela insizwa uHilton Dube, yena kuvela kwi-Q-Link Holdings, sinaye uAdvocate Joseph Makondo, yena ke uvela eCouncil for Debt Collectors, kanti endlini zethu zokusakaza eKapa. We welcome uMarissa Crozer, ovela eSummit Financial Partners. Let's start with Marissa. Marissa, thank you so much for joining us. Happy New Year to you. Compliments of the season. Marissa, tell us a bit about what prompted Summit Financial Partners to take up this fight for those millions of over-indebted consumers in South Africa. And let's talk about what prompted this round of court action, Marissa.
So Summit is involved as a consumer activist, and so we're quite involved with scrutinizing and auditing consumer loan agreements. And we've come to realize that a lot of the times when judgment is taken against consumers, collectors and attorneys end up collecting way more than double from what the consumer initially borrowed or the default amount. So for example, the consumer still owed 500 Rand on a loan agreement, end up paying back over 10,000 Rand to repay that debt. So it's the abuse of consumers that led us to investigate this and then force the courts to clarify that credit providers and attorneys and debt collectors cannot exceed double the default amount when collecting debt.
All right. And Marissa, we're going to get into details about the nitty-gritties. I mean, I'm sure a lot of people nasemakhaya bafuna ukwazi uyasho Marissa lapha mbukeli uthi cha bese bekhathela ukuthi uma phela uqale wena unesikweletu sa500 Rand kodwa uthi mase kumele phela ubuyisele leso sikweletu uma sesiqoqwa usuyibona usukhokha noma u10,000 Rand. Ake ngizwe insizwa zami la e-studio ukuthi yithini Hilton insizwa wena siyakwazi uhlale ubalwela abantu beza kunina bekhala inyembezi ukuthi hayibo naba abantu besimbe eqolo bethatha yonke imali yethu bengenayo imali yokhokha lesikweletu sokuqala uthi imali yama legal fees nani ngizoyithatha kuphi osichazele kancane ukuthi nenzani eQ-Link insizwa.
Okay, sisalisha thina eQ-Link sinama clients wethu like national and provincial government.
Yeah.
Siyahandlisha ama Garnishee orders wabasebenzi bakhona.
Okay.
Namanye ama clients from ama private companies.
Okay.
So into eyenzakala lapho i-Garnishee orders eqhamukile iyaseva on the employer and then igcina seyifikile kuthina eQ-Link.
Okay.
Masithwale leyo Garnishee order siya-audita thina siyazi ukuthi sibheka nani angithi.
Okay, izinto ekumele ngabe bayidonsela.
Exactly, kunjalo. From ama interest charges, ama legal fees, yonke lento siyayichecka sibona ukuthi isemthethweni na.
Okay.
Masibona ukuthi mhlambe kukhona ongeke ongahambi kahle, asibakhokheli labo ma debt collectors or silwisana nabo baze bayilungise le into engabi wrong ukuze i-consumer ikhokhe le mali okumele ikhokhe.
Okay, ake sizwe ku-advocate wena umele i-Council for Debt Collectors abantu esikhala ngabo ngempela ukuthi hayibona abantu besimbe eqolo kodwa ke I'm sure unamagama awise for abantu namhlanje ukuthi si-understand ukuthi lezi zinto isuke zenzeka kanjani. Osichazele nje kancane advocate ukuthi ilokhuzana i-Council for Debt Collectors nimeleni.
Yes, Swam. At the Council for Debt Collectors, we are regulating debt collectors. and debt collectors, they must be registered with the council. That's the starting phase. Any unregistered debt collector, it's a very serious misconduct in terms of the council's act, code of conduct and regulation, and will be subjected to a disciplinary hearing. And even if necessary, he may be subjected to the consumer have to open a criminal case with the South African Police Service, whereby decision has to be taken by the National Prosecuting Authority.
All right. Marissa, I mean, let's come back to you now. Let's talk about the ruling. I mean, this is a landmark ruling. I know you only represented a few, but I mean, it affects most South Africans. A lot of South Africans are over-indebted. Let's talk about how now this ruling directly affects those consumers who are currently sitting with Garnishee orders, who are currently over-indebted because of those costly, excessive recollection fees.
Well, we are very, very grateful for the ruling that we got from the Judge Hack. And it just confirmed that our interpretation of the National Credit Act regarding legal fees, collection costs, interest rates, is confirmed that you can't charge the consumer more than double the default amount. And this judgment also talked about the credit provider's responsibility to provide fair and affordable credit to consumers. The judge was quite clear on saying that credit providers cannot be allowed to over-collect on default date that they extended in a lot of circumstances, knowing the consumer can't afford the loan in the first place. So tightening the receiving end from credit provider side and restricting the amount that they can recollect through a Garnishee order forces credit providers from the starting point of a loan to be more careful when they do an affordability assessment, to ensure before granting the loan that the consumer can in fact afford the loan, and thereby also preventing credit providers from granting reckless lending. So this judgment was very, very groundbreaking. The judge went into a lot of detail about it and then confirmed at the end of the day that legal costs is included in the National Credit Act when it comes to collection fees, and that interest rates are capped, as well as the fact that before attorneys can collect on a debt that has been gone through courts, that collection cost must go through, must be taxed either by a taxing master at the Magistrates Court or by the LPC, the Legal Practice Council.
All right. Now, Advocate, we're actually besikhuluma nawe before isho iqala, and I want to take off what Marissa is saying because she's referring to this thing about a statutory duplum, which is a Latin phrase meaning double the amount of which currently abantu bachajwa. Awusichazele kahle kahle umuntu momchazela ngalo duplum usuke uchaza ukuthini and uba affecta kanjani currently with the current system yokuthi ama debt collectors alanda imali.
Yes, Swam. The Indumplam rule is been derived from the ancient Roman law doctrine, which is now part of our common law, which means that interest that is being charged stops running when that unpayable interest is equal to the capital amount outstanding. Meaning that the debt collector cannot charge you interest that is more than the capital amount outstanding. That is what the Indumplam rule means. And just to also add, the National Credit Act has further taken the definition further to specifically indicate that it must include initiation fees, service fees, administrative charges, as well as collection costs, in an aggregate amount, including the interest, not to exceed the principal debt. And that was also one of the issues in the Stellenbosch matter, whether are the debt collectors giving effect to the intention of the legislation in terms of the Section 103, subsection 5 of the National Credit Act. As it is a fact that the debtors or consumers are being charged exorbitant figures as far as debt is concerned.
All right, Advocate. Mfunu Hilton futhi athi usichazela ukuthi mhlambe are these some of the major complaints enizitholayo kuma lokhuzana kuma customers when kuma consumers afika kunina acela usizo after the break, because yabo le ndaba ye duplum kade ngifunda lana I judgment kuthiwa abameli mase beyibona bathi cha leyo lokhuzana ayisho ukuthi ama collection fees are part of le amount le esikhishwe inkantolo. Mbuke lihlala kanjalo. We coming back back with more. Uma ngabe wena ukwi-Garnishee order mhlampe kade ucollectelwa isikweletu phecelezi debt collection akhona i-debt ongasakhona ukuyisevisa sekunale imali ke manje eyiningi ekumele uyikhokhe hlala kanjalo ngoba phela kungenzeka ukuthi ubuyisele imali yakho mangabe you've been overcharged. Yilungelo Lakho live on SABC 1 Mzansi for sure. We're back shortly after this. Siphinde sikwamukele futhi mbukele ingcingo zethu ke manje they are wide open sukuthi ke manje thatha ucingo nawe phela ubambe iqhaza usibuza umbuzo noma ubeka umbono. Our studio line 0117146918 or 7146919. I-SMS line ke ithi 33721. Ungas-emaila ku consumer@sabc.co.za. Alternatively siyatholakala futhi kuma Facebook ku Facebook or ama social media networks ethu. Bengisabuza uBud Hilton ukuthi Bud Hilton yazi ngathi yaba confuse lento yokuthi uduplam in because abameli bona bathi cha but ama collection fees wethu ama legal fees or service administration bezingabalwanga kulelo khuzana kulomthetho obubekiwe, so that's how they got away with ukuthi abantu babakhokhise le imali enkulu. Nidila kanjani ngaloko Bud?
Okay, Sis Alicia thina siuquilling sine system esisebenzayo masithola iGarnishee order si capture nje wonke ama details from the judgment date ne-installment ukuthi umsebenzi umela khokhe malini, and then i-system yethu automatically iyacalculate the full amount isikoloto sonke siphelele okumele asibhadala ngithi. So and then uzokhokha mhlawumbe u500 ngenyanga masiphela leso sikoloto i-system yethu automatically iyastop leyo amount angithi. So ngaleyo ndlela sivikela abasebenzi ukuthi bangakhokhi imali okungamelanga bayikhokhe. Into enzakalayo kuneminyaka eminingi isisenze right uthola ukuthi leyo amount se uyikhokhile wayiqeda ngithi bayabuya futhi bathi umajalo usasikoloda imali yama legal fees bese yilapho esilwisana ke nabo ukuthi kanjani ngoba lo muntu useyikhokhile isikolo lesabesikoloda times 2 yabona. So ngaleyo ndlela sis Alicia kwi government space sesimanage ukuba sevela imali over 350 million rands obekumele iye kuma debt collectors namaqwetha sayistopha nje sathi ngeke nithole leyo mali.
That's a lot of money and izobuyisela kuma consumers lo mali. We're going to talk about ukuthi mhlambe bazobuyisela kanjani. Let's go back to Cape Town. Marissa, now we know of course Summit Financial Partners, this is not your first court case or major case that you've taken up. I mean, we remember the likes of Lewis back in the day and you won that judgment as well. But let's talk about, I mean, let's look at the figures. I don't know if you can give us accurate figures, Marissa. How many people currently can we say could be affected by these excessive fees or on Garnishee orders?
Well, it's very important what you just said in terms of the accuracy thereof. It's obviously very difficult to pinpoint exactly how many consumers will be affected by this judgment. But it's our estimation that from about 1.5 million Garnishees currently in effect, that about 30 to 50% of consumers are currently being overcharged on legal fees and interest.
And Marissa, you also estimate that about 1 billion rand could actually be reimbursed to those consumers. Talk to us about this. I mean, I'm sure a lot of people at home are hearing 1 billion rand reimbursement. How will this actually fare out? How is it going to pan out?
That is a very difficult thing to kind of pinpoint exactly how much will be refunded to consumers. The fact is that in order for a consumer to get a refund, they have to request a refund to be made from the credit provider. So there needs to become an action from the consumer side to request a refund, and Summit is involved in trying to see how we can assist consumers in obtaining these refunds from credit providers. And so it's very, very important that consumers take the opportunity to look at their statements and for employers to get involved in assisting their employees in both requesting full statements and stopping garnishes that have already reached the indiplam stage.
All right. Now, advocate, siyazi ukuthi kungenzeka lana kube nemali ezobuyiselwa abantu obviously njengoba iCape High Court isirulile njengoba esho Marissa. So in affecta kanjani ke lento as ibody, because I know ukuthi ama debt collectors amaningi enza i-profit merely by ucollector i-debt, and that is how they were making imali yabo by ukuthi ba charge those excessive fees.
Yes, Seswam. In terms of our act and regulations, our fees and expenses are kept, and which can be found on our Annexure B, which are also available on our website.
Okay.
That the debt collector cannot charge more than those amounts.
Okay.
Regarding your SMSs, communication, correspondences, and stuff.
Letters,
yes, they have been kept.
Okay.
So they cannot exceed those amounts.
Okay.
Although they does not include VAT, but where VAT is chargeable, VAT may be charged on those particular fees. But remember, you cannot charge VAT if you are not a VAT vendor. You must be registered with SARS in order to charge a particular VAT.
Okay.
And with regard to interest, we ensure that the debt collectors adhere to the indimplum rule, in a sense that they don't charge interest that exceeds the principal debt to the consumer.
Okay.
Yes, and how we pick it up is when a consumer feels aggrieved, he may lodge a formal complaint with the council. How he does that, he can contact our office via email.
So iqala kunina kahle kahle kumele lodge i-complaint nani iqala?
Yes, regarding a debt collector,
Okay,
yes.
okay,
yes.
okay.
Yes, regarding a debt collector, yeah. And just to highlight, attorneys are excluded from being registered as debt collectors in terms of our act.
Oh, wow, okay.
However, there's a memorandum of understanding between the Legal Practice Council, formerly Law Society, to encourage attorneys to register with the council, particularly for pre-litigation stage, before the matter start from the summon stage to a court process. So there's an encouragement so that we can be able to assist the consumers to ensure that attorneys comply with our code of conduct and regulations, since we are the regulator as far as debt collection is
All right,
concerned.
so if manje ummeli engifonele ethi ufuna ucollector isikweletu and he's not registered with the Lokhuzani Council, kumele simreporte kunina or senza kanjani? How would we then go about it?
No,
because you get those attorneys abathi bona baya collector on behalf of our clients.
No, currently they've been excluded in terms of Section 8, subsection 1.
Okay,
However,
so they are not collectors at this stage?
No, they can do debt collection. They are allowed to do debt collection.
Okay.
There's a debt collectors amendment bill that is in process, which also includes one of those aspects whether all the attorneys must be registered with the council, particularly from the pre-litigation stage, when they start collecting the debt before the matter becomes a court process, whereby they have to issue now with the summons to go and appear in court and to whether decide to defend the action or whatsoever. Yes, that is a process that is being considered in terms of the debt collectors amendment bill.
And then Hilton, do you think our consumers in dealer now are aware of this njengoba sizongo advocate namhlanje? Because I think there's always that blurry line ukuthi abantu bayathuka okokuqala nje mekufika i-debt collector umuntu uzofika zomthusa in and we can go on and on about unscrupulous ways some of our debt collectors abasebenzisa ukuthi bayolanda i-debt, of which some of which are illegal. I mean nansi advocates ihleli lapha but asimbuzi ngaloko namhlanje. So we want to understand ukuthi ilezinto inhlampo odila ngazo wena Hilton, and then abantu besuba advisor uthini mebefika kwena athi cha naba abameli sebe bathe kumina bayibona aba collector on behalf of i-client and mina I don't understand ukuthi kwenzakalani. Ubachazela kanjani lapho Nsizwa?
Okay. Baning ama-consumers amaningi abayi-understand i-legal process. Iyabathusa kakhulu.
Mabethola mhlambe hey legal what useyasaba angaphenduli ngisho amafoni.
Kunjalo. And baningi bengiba-advise ukuthi please banga-ignore, especially i-legal process le iqala nge-section 129 notice angithi. Bona baya-ignora or ama-calls from ama-debt collectors or credit providers uthola baya-ignora ngoba bayasaba. Ngima-advise ukuthi ningalinge niwa-ignora angithi. Lawo ama-credit providers ngabantu iyani kubo ema-ofisini nabo mhlawumbe uthola ukuthi awusakhona ukukhokha le mali okumele uyikhokhe, ukhulumisane nabo kwenziwa ama-arrangements ukuthi no mina ngingakhona instead of 1,000 rand ngakhona ukhokha u-500 rand. Bayavuma abaningi. So into abashayayo abaningi ukuthi baya-ignora and i-process igcina isusenkantolo and once kuphuma i-court order leya bavele bakhokhe bona but asazi izophela nini. Uthola ukuthi abaningi babatshontshela imali ngaleso sikhathi angithi ngoba ama legal fees nama interest aedwa lapho ngeke uzomangala nawe. So thina masithola ama case anjalo siqhumana nabo lawo ma debt collectors nama attorneys sicala ama documents from statement wonke ama documents abasebenzisa and before bethola judgment si-check ukuthi ama legal processes onke alandeliwe and then bese si-check again nama charges yikho la bese singakhona ukuba advise ama consumers ukuthi lana ekudlalwa ngawe makuthi i-consumer i-client yethu thina sine access to i-system siyakhona ukustopa leyo deduction if i-consumer bese ibhadele over imali bese idlulile okumele ayikhokha ngithi sivele sistope thina sibathumela incwadi ukuthi sesistopile lena la kune refund khona bese senza ama arrangements sicela i-refund.
Yazi ngeba ngibasile ngempela because ufika lapho umuntu esethi nje yazi nansi amount is like a balloon payment ungazuthi usugcina usukhokhela bangabe wakwakhokhela isikweletu walandelwa isikweletu. You know exactly what I'm talking about. Bukeli asiphinde futhi sithi sishalele ngasayitolo. We back shortly after this window. Welcome back. Ubheke ilungelo lakho. I-Cape High Court yenze isinqumo lapho mbukeli ukuthi phela ama-Garnishee orders nalabo phela aba-collector izikweletu bangabe besakucharge le mali eningi of which was close to double the amount obugcina usuyikhokha uma ngabe wena uyithola ukuthi unesikweletu awusakhona ukusikhokha. 01171146918 or 7146919. Those are the numbers to call lana studio. We are live. Mbukeli, welcome back. Vukani 2020. Ama SMSs wethu ungasithinta lapha ku 33721. Ngihleli no Marisa Chrysler ovela eSummit Financial Partners, Hilton Dube ovela eQlink, no Advocate Joseph Mokondo, we counsel for debt collectors. Marisa, I mean, let's come back to you. I mean, let's go back to the nitty-gritties of this ruling. Where does then this ruling place one's employer? Because we know these Garnishee orders actually go through HR.
Yes, so HR is notified of the Garnishee order granted against the consumer and then is required to make deductions from the consumer's salary. Now, the first thing to know is that it's very important to realize that not all Garnishees are governed by the National Credit Act. That means, for example, maintenance orders won't fall within the statutory Dublin rule and won't be able to be capped, as well as certain other debts that the consumer might own for school loans that are not necessarily incidental credit agreements. It's agreements that are regulated by the National Credit Act that fall within Section 1035 and that can be stopped if they reach the independent phase, meaning double the default amount.
All right.
Employers need to assist the employees in auditing these loans and making sure that they are not being overcharged and stop Garnishees where they suspect there's overcharging, and can they also lodge a dispute with the collector, a Section 65J dispute, to say that they are querying the statement and the balance on the account.
Those need to be very, very active employers, because siyezwa nje ukuthi Garnishee order mifika kwi-employer yakho khona bavane bathi okay nansi imali Garnishee order ifikile siyayikhokha siyayikhipha siyayihambisa le mali ayithathwe ilabantu abathi bayifuna. Sisinomasonto eLens sakwamukela Ntokazi. Happy 2020. Thank you for joining us. Umbuzo noma umbone Ntokazi?
Ngiyabonga sisi kunjani?
Ngiyaphila sisi kunjani?
Ngiyaphila. Ukuba nomasonto mhlawumbe eHigh eLens.
Yebo sisi.
Yeah, mina ngiyibhekile active. Ngingasayina i-contract yokuthi ngijima khona, but ngingekahle khona. Uthola ukuthi umsebenzi angisakhoni ukusebenza, so I can't pay le 250 abayifunayo. So bele bangifowunela bathi bazongibhekisa ngoba angisakhoni ukubhadala. Ngingababuza ukuthi okay, ukhansela bazofuna mali.
Sisinomasonto ngicela sisi if usifonela nge-cell phone, if you can move around Ntokazi, because we're battling to hear ukuthi uthini and ngiyakuzwa indaba yakho ishubi la. Siqale phansi Ntokazi, let's hear if siyazi.
Okay, uyangizwa manje?
Awumuve futhi Ntokazi. All right.
Yeah, uyangizwa manje?
Yes, now you perfect. Thank you sisi, go ahead.
Okay, ngithi mina ngiyi-victim ye-judgement. Ngisayine i-contract nabo, whatever for angisakhona ukubhadala.
Okay.
Ngiyeke eJune Day 1 and angiyanga for contract yonke.
Okay.
Yeah, so now bayangifonela bayangiblacklista bathi kumele ngikhokhe u-2,500 ekubena ngiyeke kanye kuphela.
Okay, uye kanye, but wawuyisayinile i-contract nale gym angithi?
Yebo ngiyeke ngayisayina and ngabacela ukuthi ukuyikhansela bazofuna malini.
Okay, and then bathe bazofuna malini sisonto uma ngabe uyayikhansela?
Bathe bazofuna i-2,500 so yona le ikhokha manje but angiye ukuthi malini.
Oh, and then ilokhuzana i-initial ilokhuzana i-agreement yakho nabo ubuzokhokha malini per month?
Boku-250.
250 over a 12-month period. So bathi settlement fee kumele kube 2,500. So bathi manje bathi bayakublacklista, bathi khokha le mali, bayakuhlupha nje.
No bangiqedile bathi like already
bakublacklistile. Okay. All right, Ntokazi. All right, ngicela umamele lapho kumabona kude wakho, even though your call ilokhuzana your line was not very clear. But Hilton singamsiza kanjani lana usisi uyasho ukuthi ubesayine i-gym contract and I'm sure you get thousands of these ukuthi usayine i-gym. Uyasho usisi uthi uye once. Asisho ukuthi ngoba nake once uyisayinile sisi noma sonke i-contract bekumele uwenze isivume ugcine isivumelwano sakho nawe ngokuthi uye e-gym at least once or twice a week so that uzobe wazi ukuthi le mali lo 250 okhokhayo ngenyanga. And this is it's a common problem when I put Hilton because abantu bacabanga ukuthi if I'm not using a certain service, even though I have an existing contract, I can just stop paying and then bese beyithola sekuthiwa they must pay up these exorbitant amounts.
Yeah, usisi Nomasonto usasebenza ngithi mangimuzwa kahle
usisi Nomasonto
usasebenza ngithi.
Yeah.
Right. As long as I signile le gym contract for
it's
a
binding.
period of 12 months, it doesn't matter ukuthi uya attend uya egymini na or akayi, as long as I signile kumele ayikhokhe for that duration ye 12 months.
Okay, guess it's noma sonto. Shoot awuna choice Ntokazi kumele ngempela uyikhiphe leyo nto. But u-2,500 as a settlement amount, do you think ukuthi i-rights advocate uthini wena lapho? Is this now going back to the le dupla msebefake yonke into or we just looking at the settlement amount? Ubani ongangiphendula advocate?
From our side, we are only regulating debt collectors.
Okay.
We are not regulating credit providers.
Oh, I'm a credit providers.
Credit providers falls under the National Credit Regulator.
Okay.
Yeah, we don't have jurisdiction.
Oh, so
over the
mengakandlandi, mengakakhishi umuntu ukuthi ayolanda isikweletu. Ngoba uthi bamthreatenisha manje but Hilton angakhona ukuthi mhlambe anfonele nimnikeze advice.
Angakhona asifonele yebo.
Okay. All right, sis Nomasonto, ngicela ufonele ulokhuzana uBud Hilton i-number zakhe. They've been constantly on screen and they will be on the screen throughout the show. Let's go back to ulokhuzana uMarisa. Marisa, now let's talk about this. I mean, say now this person is disputing this certain Garnishee order. Let's talk about the removal of a Garnishee order. Is it an easy process? Can everybody be able to actually to mitigate this process, and easily so and accessibly so?
Well, that is why companies like Summit is there to assist employers in auditing these loans and following the legal process in order to effectively stop Garnishee orders that have reached the independent phase. But for an individual consumer, there are avenues available, but oftentimes access to justice is not always readily available to these consumers. Because in order to stop a legal Garnishee order, the employer must play a very, very big role in assisting the employee. Because the Garnishee order instructs the employer to deduct an amount from the employee's salary. If the employer then fails to make this deduction, the employer opens themselves up to liability and can have a sheriff knocking on their door, removing some of their goods. So that's why it's important for employer not just to sit back, but to act and to make sure that they follow the correct legal process. There are avenues available to consumers, absolutely. It just requires a savvy employer to assist their employees.
All right, thank you so much for that clarification, Marisa Mbugeli. Let's take another quick ad break. Hlala nathi ngoba hey ama-Garnishee orders phela uJanuary. Ngiyazi khona bazokhala, "Mayi babo, imali yami ihambile yonke. Angisazi ukuthi ini ingane ayisaya esikoleni wara." Kodwa saniphuza njalo ngoDecember. We'll be back after this. Yilungelo Lakho mbukeli. Remember, you can now take part in our discussion. Ngokuthi usithi titi ku 011 alternatively 7146919. Ungasithumela i-SMS ku 33721 or an email ku consumer@sabc.co.za. Sikhona futhi ku Facebook ave sotholakele lapho. Sisifundisile all the way intokazi in Carltonville. Thank you so much for joining us. Umbuzo noma umbono. Happy 2020.
Hello, sisi.
Oh, butfundisile kunjani? Askisi.
Ngiyaphila, kunjani?
Ngiyaphila nsizwa. Happy 2020. Usibuzani wena namhlanje bakuphethe kanjani?
Sisi ninengxaki namapha because ninayo i-Garnishee order ebengiyibhatala from 2014 ngoMay.
Okay.
Ingxaki esiyahlabezana nayo apha. Ndiye ndayibhatala imali yakhona besithi xa iphelele iyonke i-total amount yakhona izoba yi-39,000.
Okay.
So ndabhatala ke kusukela 2014. Xa iphela kushiyeke 8,000 rand. Bavele baphinde ba-add more i-22,000.
Yebo. Bathe yantoni ke leyo yama-legal fees ne?
Bathi bona hayi le imali ukuba bayi-eddayo yayihlele vele kufanele ukuthi mayi-edde. Ndabuza ke mina ukuthi why ningasho ekuqaleni ukuthi kanti le mali xa yonke izoba imali eso or xa ngigqiba ukubhatala leyo kuzongena le. Yangisazi le 39 kuphela.
Ewe. Ke ngoku butfundisile ukuphi ke ngoku uyayibhatala ke the new amount, the 22,000 rand okanye batheni ku?
So ndayibhatala sisangangibaba kule nyanga le nguyo ngoku ndilindele ukuthi mayiphele. Cha ngakazoyisheka njengoku.
Okay. Mamela ke yazi butfundisile kungenzeka kuba wena you might even qualify for i-refund, but ngicela umame lapho kumabona kude wakho uzuba basinceda kanjani apha e-studio. Nansi ke this is what you were actually referring to earlier on, Hilton. Khawuthethe notata pha ubutfundisile. 39,000 rand was the initial amount that he was supposed to pay, and then he said when he finished paying that amount, and then they said now there's 22,000 rand that he's still liable for.
Sawona butfundisile. Yebo, la ngiyaphila tata. Yazi i-case yakho le idinga ukuthi sithole ama-documents afana i-copy ye-Garnishee order le owayithola emsebenzini angithi. Once siyithola then singakhona ukusiza. Nginethemba ama-contact details wethu ayavela lapha escreenini. Ungakhona ufonela u-Q-Link ucela uHilton Dube sizokwazi ukusiza abafundisile.
Alright.
Okay, but shoot izobuyela ke ngase-TV ngoba okwangoku ngisamuve kancane ne-TV.
Hayi akunankinga butfundisile. Iy'number zethu zizoba on our screens. Iy'number zabo ubhuti Hilton zise-screenini and also on our Facebook page, and also ishow iyarepeata butfundisile on Thursday in case wena uzobe ungayibonanga usemsebenzini. But I think you might actually qualify for laba ekuthiwa bazofumana le refund of close to R1 billion abantu abazofumana imali. Angisho ukuthi uyi-1 njalo butfundisile ungathi u-Alisha wathi ngizobuyisela R1 billion because abantu bangidlela imali. I'd love to give you R1 billion namangnayo, but all right, thank you so much, Butfundisile. All right, maybe let's quickly take a look at some of the SMSs that have come through. Somebody says on our SMSs there that they borrowed 24,000 rand. Marissa, they borrowed 24,000 rand, and the payback amount, the due amount, is now 89,000 rand. So really, you guys really had to fight for this, and it looks like it's really going to help a lot of consumers who really had no leeway or any way to get out of these debts.
Well, that's exactly why we had to go to court to clarify how the act should be interpreted. And now that it's been confirmed, now we can go ahead and enforce the law as it is currently stands. What's important to know is that if you have, say, 20,000 rand outstanding and you default on your account, the total amount that you'll end up repaying cannot be more than 40,000 rand. So you still have to pay back quite a bit of money, but not 80,000 rand.
I mean,
so that's why it's important for consumers to know their rights and to enforce their rights, to ensure that credit providers and collectors and attorneys don't take advantage of consumers that are ignorant of the law.
You know, Marissa, let's go deeper now into this ruling. Let's talk about the good news. This ruling, in effect, actually stops creditors from actually taking action in expensive high courts as opposed to magistrates' courts and so forth, and also protects the consumer from excessive charges on legal fees, etc., when you default. I mean, it's great news for the consumer already.
I'm so grateful for the judgment that we got previously on the Magistrates Court Act versus the High Court. So when a credit provider goes to the High Court to enforce a credit agreement, it really shuts the doors for consumers that would like to defend the matter. Because now you can imagine for a consumer that don't have access to senior counsel that now needs to oppose a matter in the High Court. It's very costly, it's time consuming, and access is being denied. So courts have previously said, no, if the matter must be heard by the Magistrates Court, a credit provider can't, even if the consumer consents to the High Court, the credit provider cannot go to the High Court to enforce that agreement. They must go to the Mag Court and allow the consumer an opportunity to defend their rights.
Absolutely.
And to state their case. So it's very important that consumers know that as well.
Absolutely.
And so the other good news about the 1035 judgment is that consumers can also rest assured that credit providers won't be allowed to collect on debts that are so small that are actually uneconomical to further proceed with collections. So if a consumer just owes 500 Rand, a credit provider cannot now appoint an attorney racking up fees close to 10,000 Rand to collect that small debt. They will now be restricted to the amount that they can actually charge the consumer, ensuring that there's a fair balance of rights.
Absolutely. So, advocate, I mean, it actually makes sense ukuthi yasho lana ulokhuzana ruling ukuthi aningabe nisaya kuma magistrates court because abantu abaningi mase kiwa kuma high court abanawo amalokhuzana imali yabameli ukuthi ahamba ayomrepresenta uthola ukuthi umuntu njengoba dash uBut Hilton ukuthi useyasaba akasaphenduli nalezinto at the end of the day they end up being forced ukuthi akhokhe leso sikwelete bekumele asikhokhe.
Yes, from the council perspective, a registered debt collector must only charge fees that are regulated in terms of our regulation 11.
Yeah.
And if the consumer felt aggrieved that he has been charged exorbitant figures, he is welcome to lodge a formal complaint with our legal department. And our services are for free. Doesn't have to pay. If it's a registered debt collector. Yes, he must lodge a formal complaint with our legal department and the matter will be investigated. You know, the Aldi Alteram Pattern rule applies. We have to give the debt collector an opportunity to explain why did he charge the debtor or the consumer such an exorbitant amount. And then we'll lodge a full investigation and then we'll take it from there.
Yes, without ukuthi siraise ama hopes abantu. I mean, it does make sense when uBut Hilton ukuthi le ruling ichaze izinto eziningi ukuthi ama creditors abasakhona ukwenza nje, ama debt collectors akasakhona ukwenza nje. But do you think ukuthi, I mean, we always hear of lama creditors nama debt collectors abazenzelayo noma umthetho ubekiwe, because even before this umthetho ububekiwe Hilton, but they were still flouting wonke ama processes. So do you think ukuthi le ruling will bear any weight? Siyazi ukuthi there might be an appeal none, but do you think currently as it stands izokhona ukuthi icacise indlela for abantu abaningi?
Bona thina siwuqueuing for ama clients wethu, will make sure ukuthi siya enforce le ruling angithi. Unfortunately la basebenzela ama-company mhlambe uthola i-HR or payroll department abanandaba bathola i-Garnishee order bavele badidade nje. Nginikeza abasebenzi ngibanikeza ukuthi abaye kuma employers wabo HR or payroll department babatshela ukuthi what are you doing to protect us, nisiprotecta kanjani kunama Garnishee orders angithi mabe nawo mhlambe babatshela ukuthi mhlambe akhona ama-company angasiza afana no Q-Link no Summit angithi maka basicontact sizokhona ukuthi sibasize thina lawo amanye esingazi ngawo mana kuzoba nzima ukuthi siwafinyelele ngoba abekho ku space sethu. Mara ngithi abasebenzi abaye kuma payroll departments wabo babatshela ukuthi ukhona uQlink angasiza kulama Garnishee.
Alright, anibukela uzwile ke lapho. Uyayimarket insizwa la ithi khona iQlink. Ushilo uMarisa wathi there is many avenues ungahamba uyodispute lawo malokhuzana ama Garnishee orders. Thiwa sukumani bafethu niye HR niyobuza kubaphathi bene emsebenzini ukuthi hayibo le mali esengichargewayo nengathi akuyona ngicela ukwazi ukuthi kwenzakalani, and then if behluleka ke bayidlulise indaba. Let's take now our final break. Yo, can you believe it? Ave sahamba isikhathi when you're having fun. So qhubeka emva kwale itona. Mbukeli, it's our final segment. It's in just Vanessa Ngene endabeni kade nginilayezela ngokuthi we've got your Facebook messages. I guess uthi nithini lapha ku Facebook. Usibo happy uthi, how do you then deal with a debt collector that keeps on collecting debt that is more than 10 years old and it does not even reflect on your credit records? Advocate?
Yes, in terms of our Act, Code of Conduct and Regulations, a debt collector is not allowed to collect on a prescribed debt. Normally with credit agreements, a debt will prescribe within a period of 3 years.
All right.
It's not allowed. Even in terms of the National Credit Act, you cannot collect on a prescribed debt.
So collect, because we've heard about creditors that actually resell lawo malokuzana ama prescribed debt kuma lokuzana kuma debt collectors.
Yes, if there was no any interruption regarding the prescription.
Yeah.
Bear in mind there's also prescription can be interrupted.
Kanjani, advocate?
It can be by a lot of ways, by acknowledgement of a debt,
okay,
by payment of the debt.
Okay.
Yes.
Yes,
those kind of things. And then once it's interrupted, then prescription will start to run at the time when he paid that particular debt or he acknowledged that particular debt.
Okay.
Then it runs again for a period of weeks. But as long as there's no any interruption, if the 3 years lapses, a debt collector is prohibited. He cannot collect on a prescribed debt. If that has happened, the consumer or the debtor must lodge a formal complaint with us. And if it happens, the way the debtor is explaining, will subject the debt collector to our disciplinary hearing in terms of our code of conduct and regulations.
All right,
yes.
Siyabonga kakhulu, advocate. Upete Maziboguti, I had 2 loans, so I pay the double amount of it. So what must I do with this situation? Please help me, Hilton. Utube namalona u2 and obviously bamcharge double kwi recollection. So uthi yini kangayenza manje because useyeza ukuthi ngathi kunomniningwane nemthetho ethi yazini awucheck ukuthi abazange overcharge yini.
Okay, uba uMazibuko angasicontacta ngoba ngeke ngimnikeze impendulo ephelele ngoba ngifuna ukubona ama documents uthi beka isikolo sakho bekuyimalini yena ukhokhe malini. So abalekile ama documents ukuthi siwathole size ukuze sikwazi ukwa auditor and then singakhona ukumsiza. Angasicontact uba Mazibuko asithumele lawo ma documents then sizomsiza.
All right. Now Marissa, I mentioned this at the beginning of the show. I said we're going to leave it to the final stages of the show. We are aware that the ruling is being appealed, unfortunately or fortunately, but please shed some light on this, Marissa. Does then that mean that whoever is taking action upon the current ruling, when the ruling is appealed, and then there might be new changes or adaptations to the ruling, does it then affect what has been ruled and how the people have applied their minds with the current ruling? I think I'm putting all my words in the right context there.
You're doing a great job.
Thank you.
So the judge basically decided on 3 key points.
Yes.
And the one is that legal fees in terms of the National Credit Act is included. So collection costs will include legal fees. The second point is how induplum is interpreted in terms of whether it's before judgment or after judgment, and does it run for the whole course of the default term, and also whether or not legal costs should be taxed before they can be collected. So only the second point was appealed by one of the credit providers, Bayport, and that will now go to the Supreme Court of Appeal to make the final ruling on it.
Okay.
The other 2 points, the fact that attorney's cost is included under the National Credit Act and the fact that legal costs must be taxed, those 2 points are not currently being contested and they still stand. The other point is that this is a declarator order, meaning the law is still what the law says. There's no change in the law.
Yes.
So we, from Summit's perspective, believe that the correct interpretation was granted by the Cape Town High Court and that is the one that should be enforced.
Okay.
But it's a matter of dispute between the parties. So until the Supreme Court gives final clarity on the matter, making it much easier to enforce the induplum rule the way it's currently being stated in the National Credit Act, it will be open for dispute by parties.
All right, Marissa Chrysler, thank you so much from Summit Financial Partners. Thank you so much, Marissa. And I'm sure a lot of people can also still go to your website to look at this ruling and also get pointers and also educate themselves about what this ruling really means, because it's a lot of duplum this and duplum that. So a lot of people need to just educate themselves. Very quickly, Hilton, amagama akho okubalances.
Nangithi usizo lukhona bantu bakithi. Ukhona uQlink anganisiza la ngibona ngathi kukhona ongathi akuhambi kahle ningamcontact uQlink uzokhona ukungisiza abantu bakithi.
Edvov wena uthini ebantwini?
Yes.
Edvov wabantu.
If the consumer feel aggrieved by the conduct of the debt collector, he may lodge a formal complaint with us, with our legal department, and our services are for free. And we'll deal with the matter. The matter will be investigated up until its finality, and we'll give the consumer a feedback.
All right. Thank you so much, my guest today from all the way from Cape Town, Marissa, looking so pretty with that beautiful view. Marissa Chrysler from Summit Financial Partners. Thank you, Hilton Dube from QLink, and of course, advocate Joseph Mokondo, we counsel for debt collectors. Mbukeli, hayi kuphela kanjalo ke bengikuphathele kona our first live installment yohlelo lethu. I hope ukuthi nginisizile ke seniyazi ukuthi meniphuma la nigijima niyaphi khona sizozama ukuthi save imali. Guys, it's 2020. We need to have plenty of money. Ihlelo ke liyaphinda ngolesine right on SABC 1 eMzansi Ngoshongo 11 kuya 12 ebusuku from me uAlisha Ntokazi kaJali phansi amanzi imtoti ngithi nje isale kahle.